SJC-13223, Commonwealth versus Anildo, Correia.
Good morning. Good morning, Chief Justice Budd and Associate Justices, and may it please the court. Eva Jellison on behalf of Anildo, Correia. I'm going to spend most of my time on the rap lyrics, but I, of course, welcome any other questions. Here, irrelevant and inflammatory rap lyric evidence reached the jurors, and they were permitted to use those rap lyrics for any purpose. The lyrics were inflammatory based upon their content: violence, guns, shooting, gang imagery, hostility towards the police, prior bad acts. But also,
that there was no limiting instruction.
there was no limiting instruction.
I recognize that. But on redirect, after the mistrial was denied, the defense attorney brought up the non-propensity purpose for which Judge Davis seemed to have allowed the evidence in, as it relates to how the defendant would have taken the victim's statements, considering the defendant's own postings and state of mind. That was the theory of relevance. Why is that theory of relevance not available as a non-propensity purpose?
So I think, so you're asking a question about relevance. You're also asking how it came in, so yes, on redirect, Mr. Correia described what the rap meant to him. So I'm gonna go all the way down to, I think I'll say this first. Let me preface this. Even if these lyrics were marginally relevant in any way, they were substantially outweighed by their prejudicial value. But I can jump into relevance first. And I also need one more preface. I'm gonna get to how Mr. Correia would have interpreted the post, I promise. But one more preface. This court in Gray stated that that rap lyrics shouldn't necessarily be taken as literal. And before we can take these rap lyrics as literal, I think I would ask the court to adopt some sort of standard to say that there's a strong nexus of fact between the lyrics and the case before the rap lyrics can be taken as literal.
Isn't the defense premised on a literal interpretation of rap lyrics too? I mean, the basis of the self-defense is a rap lyric, right?
So not exactly, and it's a little bit different. So the reason that Mr. Correia understood what Mr. Martin said directly to him was because those phrases were made popular by rap music. So during this fight, Mr. Martins states to him, "Do you know how the hot shit feel?" And to him, because rap is popular in their community, he understands that to mean,
could I go
I'm going
backwards
to
for a
shoot
second?
you.
I'm not sure
Absolutely.
that Justice Kafker was alluding to that, because if I remember correctly, Mr. Correia said that there were Facebook postings where the decedent had quoted other rap lyrics that Mr. Correia used and that was used by the defense in the state of mind of Mr. Correia as to why he thought he had to resort to what he did. So if you could go back to that for a second, because I'm wondering why it is that we get to consider the content for the truth when it's to his benefit as to the reasonableness of his fear, but in converse, we can't consider it when it comes to the rap lyrics that he posted. Can you explain that to me?
So there's an element of temporal proximity here, just to start with, and that's discussed in some of the cases in the other jurisdiction. So the lyric that you're referring to, and you can see it as Exhibit 60, was posted as a single phrase on Mr. Martin's Facebook only hours before this fight occurred. It was not an entire rap song. It was not a very long lyric. It was a specific phrase that he selected and posted with a picture of himself, not, a picture of the rap cover or something like that, picture of himself, a specific phrase, and it included the word murder. And it wasn't used, so the idea that the evidence was relevant to Mr. Correia, that he, as the judge said, that he felt like he needed to stab Mr. Martins because of postings, that's not quite right. That's not what Mr. Correia testified to. Mr. Correia testified that when he was threatened directly by Mr. Martins with a shooting, when Mr. Martins reached toward the backpack, toward the zipper, where a gun could have reasonably been kept, and since Mr. Martins had been wearing this clothing that indicated that he was up to no good, in that moment, Mr. Martins also remembered that he had seen only hours before that Mr. Martins posted the word murder. Now, did Mr. Correia explain what that phrase meant, sneak dissing, based on a rap lyric? Yes. That was how he understood what Mr. Martins had posted only hours earlier.
Well, but
So
there's
that's a
ano-
little
but there's
different
another-
than,
There's another rap lyric, though, which is the first.
the first one was
hot-
said directly to Mr. Correia during the fight.
But again, you have to interpret it literally, right? If your whole basis of your argument is the rap lyrics are metaphorical or, personas rather than the person, we're interpreting the other phrase literally, though. You want us
Right.
to have it, it's a two-way street. We
So
need to be
these are
consistent.
different things, respectfully, Justice Cosper. These are different things. And when you state a phrase during a fight at someone while you're reaching to a place where a firearm could reasonably be kept, that has a strong nexus to the facts of the case.
And
When
in
you
fact,
post
counsel, it wouldn't matter whether it was a rap lyric
Or
a
anything
piece
else.
of poetry.
Exactly.
The meaning of the words are what count, and the fact that the person said it.
Right, so in the context, and I think that's what Gray talks about, we have to see what the context
But
of
the
this
exact
is.
words are, you know how the hot shit feels, right?
Right.
That's not self-explanatory.
Maybe not for us as, older white people, but for somebody who lived in that community at that time where those, that music was popular and they were all listening to it, it meant exactly, I'm going to shoot you.
But she's going to get up and say the exact same thing about what your client said.
So I didn't actually end up finishing my answer about the temporal proximity. Mr. Correia posted entire songs 11 days before this incident. They didn't talk about anything specific to this incident. Mr. Correia did not reference any of his lyrics during this incident. So if you're using a lyric during a fight, looking at someone, telling them, do you know how the hot shit feel? And then reaching into a place where a gun could reasonably be, that has a strong nexus of fact to what's going on. If you post 11 days before lyrics that are generally violent, generally about shooting, generally about themes that rap often incorporates, there's a footnote in Gray where they cite a study that says that 65% of rap music includes violent themes. This is common. This is not the same thing as a strong nexus of fact where you're being threatened with a specific phrase at a specific time during the fight. If Mr. Correia had said any of these lyrics during the fight, they would be relevant, and the songs might be relevant, but he did not.
I'd just like to go back to my initial question.
Absolutely.
There's all these theories of relevance about the Glock or North and South.
Mm-hmm.
That wasn't the theory of admissibility.
It wasn't.
So this is all well and good, but there's no limiting instruction, and that's not the theory of admissibility.
Absolutely.
So Judge Davis lets it in because he believes that it's important to hear the defendant's statements to understand how he would have taken the victim's statements. That's the theory of admissibility.
Okay.
Right?
So, yeah, and
Okay. Now,
yes.
That's the theory of admissibility. All this other stuff is not the theory of admissibility.
Okay.
The defense attorney on redirect brings all that evidence out into the forefront, the exact theory of relevance. How did you think, what'd you think of the rap?
Mm-hmm.
So why isn't it, if the jury, certainly at least if they'd heard a limiting instruction, be able to focus on that relevance?
Well, I mean, if they didn't have a limiting instruction and they could have used it for any purpose, and, whatever defense counsel was able to do with it after she was unable to get it excluded, I don't know if you're asking, does it make it relevant or does it somehow cure the prejudice? But it doesn't make it relevant because she had to discuss what the rap meant. But I would like to go how Mr. Correia would have interpreted the post, because that is the theory of relevance. Right. So, number one, it's a little too broad. Mr. Correia, how someone would, if a certain online post is relevant, doesn't necessarily mean that all online posts are relevant. And it's a little apples to oranges. We have a rap song versus a photograph of Mr. Martins possessing a firearm, which defense counsel used and in her argument and asked Mr. Correia questions about, having to do with, or Mr. Correia responded that when he heard Mr. Martins threaten him, he thought back to the fact that he had seen photographs of Mr. Martins possessing a firearm. So it's a little bit different than a rap song. And again, I think selecting a particular lyric, including the word murder, 3 hours before you go to the park dressed in the manner that Mr. Martins was, that has a stronger nexus of fact. And, defense counsel didn't argue that, I'm sorry. I think it's a stretch to say that Mr. Correia was thinking about how his rap songs would have affected the fact that he saw Mr. Martins post a firearm or posts the word murder.
But
That
it's
leads
not,
to,
I'm sorry, Justice Lowy.
you go, please.
But
Justice Wood.
I'm still back to Justice Lowy's theory of admissibility. I understand that, particularly as an advocate, you might be saying that, but the question is whether or not the jury could consider this, because on the one hand, you're arguing that even though we're not talking about just the temporal proximity of the hot shit lyric, but the other stuff that was posted on Facebook, that all of that went into the state of mind of Mr. Correia when he did what he did. And so to the answer of fighting kind of fire with fire and saying, if you're asking the jury to believe the reasonableness of his apprehension, why shouldn't they get to also consider that he posted rap lyrics? And it wasn't the all songs that she used at cross-examination. It was particular lines, to which on redirect he got to say, these were all just boasts. I didn't really mean it. This is just me. Why shouldn't the jury get to consider that when they're also considering the reasonableness of his apprehension? It's all the same thing. Why is that wrong?
I do think that the relevance is very low if it exists at all. And I believe that because I really do think this is apples to oranges. Posting an actual picture showing possession of a weapon versus a rap lyric, posting a rap lyric temporarily to this fight versus 11 days before. But even if the court finds that this was somehow relevant to how Mr. Correia would have interpreted posts in light of the direct threat, the clothing, the reaching toward the backpack, then this evidence was more prejudicial than probative and substantially more prejudicial than probative.
Let's assume for a moment it is, because you're running out of time. The jury came back voluntary manslaughter. They
Yes.
clearly didn't accept for the truth of what was said against the defendant. So Justice George's point, I think, is well taken. We're trying to decide who's the first aggressor and all those issues, and why shouldn't the defendant's state of mind come into play if the victim's state of mind is in play. But nonetheless, the jury comes back not deliberate premeditation. They clearly don't accept the lyrics for their truth or for their propensity purpose.
Right. So I think I just want to say one thing about prejudice. I'll move on to prejudicial error, but rap lyric evidence is inherently prejudicial. The amicus brief is wonderful. Read it. It talks about
By the lack of a limiting instruction that the defendant should have asked for, that the Commonwealth should have asked for if the defendant didn't, and the judge should have given even if neither side asked for it, should have been done because of all those reasons. But that didn't happen.
And respectfully, I don't even know if a limiting instruction would have mitigated the prejudice here. This evidence is inherently prejudicial. Jurors see rap lyrics as more offensive, more threatening, more dangerous. They see Black rap artists as particularly criminal and violent.
A first-degree murder, and
They
they
didn't.
didn't
And I'll-
convict him
and
of
I'll-
second-degree
and I'll
murder.
move on.
They got to voluntary manslaughter, which suggests they weren't interpreting it that way that you're suggesting.
Well, but they could have, but they
Would
could
have
have
been a not
interpreted it
guilty? Is that
exactly
what-
this
is-
way. So the jury could have used this evidence to determine that Mr. Correia was a violent person, a violent, bad person who would have used more force than necessary in this case. The jury could have perceived that Mr. Correia was a violent, bad person who did something wrong. You know, this was not justified. He at least did something wrong. You know, he's a violent, bad person, and he would have used more force. He would have done something wrong.
Enough force. I mean, there were 12 stab wounds.
There were not, so just to be clear, there were not 12 stab wounds.
Was it?
The medical examiner's evidence is very clear. There were, I think, 3 wounds that could be considered to be stab wounds. There were 6 wounds on Mr. Martin's hands, and I would direct you to my appendix. I have pictures of those wounds. And there were additional wounds.
Which one was the cause of death?
There were 2 that both, the medical examiner said there were 2 wounds that both were serious enough to cause death, and one of those was to the chest and one of those was to the abdomen. But the repeating of the 12
Counsel,
stab wounds was
is
actually
it your
quite
position that
prejudicial.
if these lyrics weren't in, the jury could not have so concluded all of those things about Mr. Correia based on all the other evidence that came in? Because it was substantial.
No, the evidence in this case was really thin. A lot of it was through grand jury testimony, and the witnesses had.
Well, he was concerned about his cousin. He armed himself. He went to the park. He found his cousin. He didn't take his cousin and leave. He stayed. And he inserted himself after the reason for coming there was already obviated because he found his little cousin. He could have left. He didn't call the police, all these other things. So there's plenty of evidence that they could have of decided that he came down there on a purpose, other than these rap lyrics.
I take a little exception with some of the things that you said factually, and I just want to hit a couple of them. There was no evidence that Mr. Correia armed himself specifically for this fight. There was
I didn't say that. I just said that he came down there with a knife.
Okay, you said he armed himself, and he.
That's not arming yourself? Coming down there with a knife?
If you always carry a pocket knife, and that was the evidence, he didn't arm himself specifically for this fight. And the evidence was that
Over
when
his head.
he, excuse me?
Pulls the short shirt over his head like it's a hockey fight, and makes, maybe there's not 12 stab wounds, but there's 12 contacts. And the issue and the issue is whether it's excessive force in self-defense, not
Right.
whether the rap music was used for its truth as it relates to premeditation or intent.
Right, but the rap lyrics they were permitted to use it for any purpose, and I believe that they could have used it to think that Mr. Correia was a violent person, and that he would have used more force than necessary. And just to the hockey fight point, the facts of the fight are described very differently by different witnesses, and it is very possible that the point at which Mr. Correia is engaged with the sweatshirt, that there was only punching going on. So I would just direct the court to the facts
Can I
as
ask-
stated.
What rule do you want us to change our prior case law on rap lyrics? Because you argue at some points for a sort of a bright line rule that rap lyrics should, it's too hard to separate fact from fiction, the person from their persona, and we shouldn't do this. Is that what you're arguing, or you're not?
Yeah, so I'm arguing for not really, so Grace.
Let me just add one
Oh, sorry,
element.
yeah, of course.
And what happens when the defense is also turning to rap lyrics? Because we can't ignore that, rap lyrics are on both sides. So because the most interesting part of the case, the most important part is how should we treat rap lyrics? So what do you want us to do differently?
So first of all, I think you can treat, where Correia's posting an entire rap song and Mr. Martins is choosing specific phrases at specific times, I still think there's a difference. But you can apply the standard that I'm asking for to both of these things, which is if you have a threshold standard, recognizing, and Grace says this, Grace says that we shouldn't necessarily be taking this form of art literally, so when can we take it literally? And I would suggest that the court have a standard for that.
What is the role of the judge in terms of limiting its use? Again, because it's complicated.
I think the judge should act as gatekeeper, and I believe that the judge should determine whether or not there's a strong nexus between the facts subject to prosecution and what's in the rap lyrics, and decide whether or not, therefore, the rap lyrics can be taken as literal. And that would provide...
Gray and Gray?
Gray is a little bit less clear than that. So I'm asking for a clarification of Gray mostly on that point to say, when can we take these literal, strong nexus of fact, sufficient level of similarity with temporal proximity, whatever standard you might fashion. There are a lot of cases in different jurisdictions that use different language.
Whatever we come up with?
I think under any of the standards that I've cited, that these lyrics would have been inadmissible. So I would be happy with whatever you come up with.
So I'm sorry, can you answer Justice Kafker's question? It's a strong nexus.
Strong nexus.
Temporal proximity.
Yes.
Anything else?
No, and I guess I just want to give you
Clarify, Gray.
an example of something that would have a strong nexus and a temporal proximity, just to kind
Well,
of...
I mean, I think we have an example in the Seventh Circuit's case in Foster, right?
Yeah, or any of the cases where there's a confession, some sort of thing like that. That's a clear, easy example. I think some of the examples like this, where the rap lyrics were posted far before written, probably even
Does your
further.
rule work both ways?
Say it again?
Does your rule work both ways?
It should. And it would work well. It would work in this case. The phrases that Mr. Martins posted and uttered during the fight had a strong nexus to the facts of this case.
But let me push back on you on that, because if I quoted something from some sort of 19th century or 18th century poet in the moment, it doesn't seem to me that the temporal proximity means anything for what Mr. Martins suggested by his quote. Right?
I mean,
it could have been a rap lyric from like the 80s. Who cares? It was a threat.
Right, it was a threat during the fight. So I guess to the extent there's temporal proximity, it was during the fight.
Yeah, but the lyric itself need not be written then.
No.
Right.
No.
Okay.
Sorry, I wasn't clear.
Okay, any other questions? Thank you.
Thank you.
Okay, Attorney Black.
Good morning. May it please the court, Johanna Black for the Commonwealth. So this defendant, with respect to the rap lyrics, tells the jury on direct examination that he views or considers rap lyrics to be literal statements of a rap performer's state of mind. So here he's telling the jury the victim who's quoting another rapper, another artist's lyrics, meant them literally, and that he, as a rapper himself, took them and interpreted them literally. That is evidence of what the defendant thinks when he writes his own lyrics and performs his own lyrics. It's evidence.
Even when he's performing under a different persona, he's got a name. He's not it's not his rap lyric directly. He's doing it as, I can't remember what, attack $sign or something like that. He's got a particular
Ace stacks.
Yeah, that he's separating himself from the person performing in certain ways, isn't he?
So many, if not most rappers have, different names than the names they were given at birth, including white rappers. And there's evidence at trial that this defendant went by the nickname Ace, and the name he uses on YouTube to which he posts his rap music is Ace Stacks. So
That's what his friend,
sorry.
what his friends call him? That's his name out in the community, or is that the name when he raps?
Ace is his name out in the community.
But the
Ace
name
Stacks is the name that he is his profile name on YouTube. The victim's profile name on Facebook, another social media forum, is also not the name he was given at birth. It's LJ Capone, which, according to the defendant, is a reference to the rapper L.A. Capone. So I don't think that fact in of itself is really deserving of much weight in trying to determine whether to take the defendant's own lyrics literally or not.
But assuming that the defendant's lyrics are relevant, what do we do about the fact that there was no limiting instruction?
So I think the fact that on redirect, the defense took the opportunity to allow the defendant to explain that what he writes or he performed were not literal descriptions of his own life. It was about what he viewed in the community around him. I think this court can consider that.
There's a problem. The objection has been overruled. The motion for a mistrial has been denied. And now the defense attorney on redirect asked questions. You're absolutely right. That was my first question to the appellant. Asked questions going exactly to Judge Davis's theory of admissibility.
Right.
But what's the defense attorney to do at that point? The rulings were all lost. Now the defense attorney has to use what the defense attorney has.
Well, I think where the defense was relying on the literal interpretation of the rap lyrics used by the victim, a limiting instruction to tell the jurors that, rap lyrics may not be taken as literal. I mean, that would, what would be the,
Different instruction.
I guess what would be the limiting instruction?
So the victim's, the defendant's state of mind and the victim's state of mind are two different theories of admissibility, and the judge has the ability to give a different instruction as to both. So that's not really fair.
Right, but I don't, the only, the Facebook post of the victim holding a gun, or what appeared to be a gun, with the caption, "Don't let us sneak this into a murder," that the defendant says he viewed right before the fight, that wasn't admitted for the victim's state of mind. That was admitted for the purpose of the defendant's state of mind. Judge Davis, I believe, the only other evidence that was admitted relevant to the victim's state of mind was adjutant evidence, which was the DYS punch. And he would have allowed in some other incidents had the defense come up with admissible evidence of them. But the Facebook posts by the victim, Judge Davis finally allowed those in when the defense started to say, we're going to put the defendant on the stand and testify that he saw them. And that's when the lower court believed they became relevant to the defendant's state of mind.
Yeah, but the chief's question, what about the limiting instruction? They could have used that evidence to think this is a north-south animosity.
So you're asking,
no limiting instruction.
so you're asking that if it was a problem, there was no limiting instruction, essentially limiting the jurors' consideration of rap lyrics, that they cannot take them literally? Is that what you're?
Well, it's available for all the propensity purposes because there was no limiting instruction. Judge Davis allowed the evidence in, as you just said, as it speaks to what the defendant's state of mind was, because this is who is the first aggressor for excessive force and self-defense. It wasn't admissible for the truth of those words because that's not why Judge Davis allowed it in, but the jury could consider it for all those reasons.
Well, so my understanding of the case law with respect to just general prior bad acts is that a court doesn't have to sua sponte give a limiting instruction, that the defense should request one, and if they don't, then on appeal, we're in a different posture than how they asked for one. But with respect to whether the jury should have been instructed, don't take these for the truth. They may not necessarily be able to be interpreted literally. That wouldn't have helped the defense because their whole defense was based on the victim using lyrics in a literal way. So that would have cut against them as well. And it was more strategic for the defense to just have the defendant on redirect explain, yeah, but I use lyrics as an art form. I don't view my own lyrics as communicating.
No choice. And your point about the limiting instruction, it's not just about the appeal, it's about the fairness of the trial. When you're weighing probative value and undue prejudice, you got to contemplate the effectiveness of the limiting instruction.
Right.
So it takes everything.
Right, but my understanding of the law is that the court does not have to sua sponte.
This is my point.
Right.
What we're doing right now, go back to Chief Justice Budd's question. What about no limiting instruction and the prejudice? When you're balancing probative value and undue prejudice, you have to do it contemplating the effectiveness of the limiting instruction, telling the jury to compartmentalize their minds and use the evidence only for the purpose for which it's admitted.
Right.
And that didn't happen.
Are you arguing that the burden was on the defense attorney to proffer limited instructions? We're speculating as to what the limited instruction could be.
Right.
That was the defense attorney's job, right?
I think I am saying that in part, and I think I'm struggling a little bit too with what would be the limiting instruction. So in this case, if you're saying the judge should have just told the jury only consider these lyrics for the purpose of the defendant's state of mind as to evidence of his state of mind, then I think, there was other evidence that there were two essentially groups of friends. There was, sorry, you're shaking your head.
I'm just saying, as to that piece of evidence, he admitted it as it related to the defendant's state of mind. Just that piece of evidence. Just that. And that's where the limiting instruction would have been, so that they couldn't use it for propensity or the truth of the lyrics.
Right. So with respect to talking about the Glock, things of that nature.
And North and South.
Well, North and South, I don't think doesn't, it kind of gives it's not just about the defendant's state of mind. It kind of gives the jury a full picture of what was going on. There were these fights that were going on all over the park, and there were over 60 kids, I think about 100 kids. And, other bad acts can come in, not just for a state of mind or intent or motive, but also to provide the jury with a full picture of kind of the atmosphere of what was happening at that time.
I have not heard of that one, that exception to letting in prior bad acts for atmosphere.
For a fuller picture of what was happening. So like in DV cases,
But that's not why he decided to admit it.
Well, we didn't really get into it. Well, no, he did. So early on in the trial, when defense was trying to exclude any gang evidence, and the Commonwealth was saying, that was the reason these fights occurred, the judge ended up limiting that evidence to essentially it was a fight between friends, and that there was a loyalty amongst friends that didn't need to reference gangs so he was allowing it in for, the kind of reason this chaotic atmosphere came to be. It wasn't, the discussions and the arguments weren't
Counsel, when
focused
you say
on the
he
defendant's
was
state of mind.
allowing it in, are you talking about the rap lyrics or are you talking
The gang evidence way at the beginning of the trial.
Right, so that's not really the issue that we're talking about here. I mean, the problem...
Well, it is. It's the same thing. It's north-south it was South Side against North Side. That's what the Commonwealth was alleging, and the
If I
judge
could
didn't
just
want them to
finish my
use.
question, that would be great. So it wasn't, that evidence already had come in, right? Now we're talking about, on this appeal, we're talking about the lyrics regarding the North versus the other South Side. And I guess I'm wondering why the limiting instruction would not have been helpful and
it's
important,
right.
because the reason the judge seemingly let it in was to go to the state of mind of this particular defendant. He's someone like this defendant, as
The
the
lyrics.
judge said. Yes.
But what they said was also in evidence in other ways. So, for example, the South Side being at war with the North Side, that was already in evidence as the fight between friends that had been discussed earlier in the case about how when the defense moved to prevent the Commonwealth from using the word gangs. So that was evidence
Already
separate from the
in,
lyrics,
yeah.
right? But it's the same information.
So you're saying it
limiting
wasn't prejudicial because it was just more of the same? I don't understand your argument, I guess.
Well, my argument is that that evidence about North Side being at war with South Side wasn't just admitted to go to the defendant's state of mind. It was also providing the jury with how all these fights amongst about 100 kids came to be. And that was all discussed well before I think the Commonwealth even knew that lyrics were going to be introduced.
So
at
are you
trial.
saying it was cumulative? I'm confused.
No, I'm just saying the limiting instruction pertaining to the rivalry between the friends or the gang or the North Side versus
No.
South
The
Side.
limiting instruction, as I understood it, would have gone to the use of these rap lyrics to prove a particular thing. And so the limiting instruction, I would have thought, would have been, you can only use these rap lyrics for the defendant's state of mind. What is the Commonwealth's problem with that?
Right. Well, I think it
instruction?
also went to providing the jury with an accurate picture of what was going on at the park at the time the defendant stabbed the victim.
I love my Glock, now you're dead. How does
So
that
sorry, I'm just
affect-
focusing on the rivalry. But if we could move on to the firearm stuff, I mean,
Can you really separate that? I mean, can you separate them so finely that this one applies to rivalry and this one applies to the gun?
yes, because if you're just looking at lyrics, rap lyrics, separate and apart from the acts or other wrongs that they discuss, that's a different issue of admissibility and reason for admission. The acts that they discuss, which are different acts, may come in under 404B for different reasons.
Don't we, back to the question I asked your sister, we need a limiting, we've got to not allow rap lyrics in generally. There has to be that factual nexus to what's going on, right? Meaning, this shouldn't be in the case unless he's somehow describing what's happening here or what he's planning on doing, right?
Well, I think the defense has a very narrow, inaccurate view of relevance. And, evidence depends on not just direct evidence, but circumstantial evidence based on inferences. The Commonwealth can use...
Bear with me for a second, because we asked them, what do they think the rules should be on the admissibility of rap lyrics? And they talk about a factual nexus and temporal proximity.
Right. It can't just depend on...
This discussion of Glocks, it's clearly has nothing to do with the facts of this case. This is a knife fight.
It does, though, because the defendant injected evidence about the victim having firearms, and that's the whole basis.
His description of him having a Glock?
It shows his knowledge and his experience with firearms and the reasonableness of his fear when a victim is posting that stuff to social media. And so you can't just categorically exclude information from trials, especially not lyrics, which are statements of a defendant. You can't just make them admissible only when they strongly relate to the specific details of the crime.
Why not?
Or when they strongly, because, for example, that's to me, I
Why not?
interpret
Given
that.
all of the studies and the various conclusions about how people view rap lyrics, the tendency that they associate with rap lyrics in particular, as opposed to country music, with violence and gang association, all the reasons that you're actually standing there saying we can use them are all the reasons why perhaps we shouldn't, and certainly shouldn't without limiting instruction.
Well, so because rappers talk about their lives too. It's not just about the details of one crime.
Well, so do country,
I think it might be in the
Western singers.
amicus brief.
Country western song that's about drinking, that we're going to allow in an OUI case.
If it becomes relevant,
Really? I mean,
yes. So there's a statement about, Bob Marley in Gray and how he sang,
I shot the
shot the sheriff, but I didn't shoot the deputy, I think is the lyric.
That's right.
So obviously we don't take that literally. There's no any indication that those are literal.
It's a famous
If there was
song,
any, right, that was made famous, I think, by Eric
So for
Clapton. But
an OUI case, they pulled the defendant over, and I Love This Bar is playing on the radio.
right.
Is that admissible?
It depends. So if he says if it's his own song and he admits I went to that bar earlier, if there's other information that is indicative of how those lyrics apply to the case, like that makes them relevant, then yes, maybe they should come in. I'm not saying.
Isn't that exactly what your opposing counsel was saying? That you limit the admissibility to some situations where there's a close nexus?
Right, but it can't just depend on defense's version of the crime that occurred or the details in the defense's story about what happened at that particular crime. I mean, there are so many cases, especially murders, domestic violence cases, that depend on the history well before the actual crime occurred.
The relationship between the victim and the defendant. How did the rap lyrics illuminate the relationship between the victim and the defendant?
Well, the victim's friends with people on the north side. The defendant grew up on the south side and friends with people on the south side. And there's evidence at trial that there were, so for example, I think it was Terrence Taylor talks about Arias, Jose Arias himself and Johan Martins being friends. And, I believe Jose Arias is from the north side, and how when the fight started between Jose Arias and Sauvignon Brandon, friends of Brandon's jumped in, and that's when the defendant says, I jumped in to protect Brandon. They're both, I believe that the defendant himself testified that they're both from the south side, but at a minimum.
See how that exacerbates the prejudice? You didn't have a chance, or you didn't answer Justice Wendland's question about what about all this other evidence of north-south, or the defendant's view there might have been a gun in the backpack. The rap music wasn't admitted for that purpose. You point out there's all this other evidence of it, but if you have this rap music that corroborates that wasn't admitted for that purpose and may well not have been when you're weighing probative value and undue prejudice because of all the concerns about rap music, then this other evidence actually exacerbates the problem with the lack of a limiting instruction.
Well, the judge admitted the rap lyrics for the defendant's state of mind with respect to his self-defense claim.
To the jury, right?
No,
I guess,
but
that's back to the Chief's initial question. There was no limiting instruction.
right, but you can't just view the admissibility of evidence through the whole of the story that the defense wants you to believe. I mean, the Commonwealth had a whole different theory of the case that it's entitled to present. And when the judge admits—
Because he was a rapper, he was
No, but if there's a
tended to be
rivalry between two
violent
groups of
and
people
gang.
and one on the other side is showing guns and this defendant is showing guns, like it does go to his state of mind and whether he really was this.
What does it matter, your theory of the case, if the judge makes a pointed decision about the only reason why he's allowing in a piece of evidence?
He didn't say it wasn't for the Commonwealth's theory of the
He
case.
said he's letting it in to
For the defense state of mind.
Right. So forget about your
That's the Commonwealth's rebuttal to the defense's raising a
Sure.
self-defense claim.
but
We're
that's what-
showing it wasn't done in self-defense, that there was a rivalry going on. He wasn't that afraid of someone on the other side flashing weapons because he himself communicates to the world by his public postings to YouTube that he knows about firearms. He flashes firearms around and that there's this rivalry going on. It came in for the defense state of mind, the lyrics.
Okay.
But the acts they discuss can come in. Can I just say one other thing very briefly on
I have one last question.
Okay, yeah, I mean, we've talked about this a lot, and I think we get where you
Can I
stand
ask
on it.
one last question about, say we disagree with you and we think this was error.
Right.
The standard review is what, and why don't you tell us how you meet the standard review if it was an error?
Sure, it's substantial risk. It's not prejudicial error. And I just want to kind of recite why, because I know defense brought this up again in reply. The initial objection that defense raised at the appropriate time was based on notice under adjutant. You can't ignore the legal grounds the defense moved under in front of the lower court at the appropriate time to raise an objection, which was notice under adjutant. Adjutant applies to a very specific category, subcategory of prior bad acts, and that's specific acts of violence. And there are notice provisions associated with that case. And so to the judge, and you can tell by the way he responds to it, he uses, in his response, at one point he did use the general term prior bad acts, but he's saying again, and it looks like there's a typo in the transcript that—
You're arguing the merits again. I'm just trying to say we disagree with you. I'm giving you a chance to explain why this error is not reversible error, if it is error.
say you agree with the Commonwealth on substantial risk.
No, I haven't figured out whether it's substantial risk or prejudicial error, but I
Right, and I was just trying to explain why it's substantial risk.
Okay, go ahead, sorry.
So the only objection that really would preserve any rights for appeal was the one the council made on April 2nd, and that was objection as to lack of notice under adjutant. It wasn't about First Amendment speech or Gray.
Assume it's a substantial risk analysis.
Right.
Now tell us why it's not a substantial risk.
Because of the strength of the Commonwealth's case, even aside from that, and also the fact that the defendant wasn't convicted of first-degree murder. He was convicted of voluntary manslaughter, which to get there, one of the ways to get there is when a person uses excessive force in self-defense. So there is a very strong likelihood that the jury believed the defendant's self-defense claim, and that's how they got to voluntary manslaughter. But the rest of the Commonwealth's case was very strong. I mean, just because the police described contact between the defendant and the victim as uppercuts because they couldn't see super clearly what was going on, that is circumstantial evidence of when the stabbing occurred. So, the defendant didn't end up challenging identification, and it really just boiled down to whether he acted in appropriate, reasonable self-defense. So, and if you're looking at substantial risk and the fact that, so I think it's just the strength of the Commonwealth's case and the fact that he wasn't convicted of first-degree murder, that the conviction is supported by the evidence, apart from the lyrics.